Okay, we're just going to get started. Welcome and thank you all for attending the Duke Journal of Gender Law and Policy's annual symposium. Before we begin today, I'd like to take a moment to thank all the people involved in this event, without whose effort none of this would have been possible. First, to our distinguished panelists for taking time out of their busy and impressive schedules to share their work with us and to participate in this dialogue. To Dean Levy and the faculty at Duke Law, particularly our faculty advisor, Professor Bartlett, and Professor of Healthcare Law and Policy, Barack Richmond. To the members of the journals themselves, especially this year's executive board, our editor-in-chief, Amelia Hairston Porter, our executive editor, Julia German, our managing editor, Virginia Martin, our note editor, Jennifer Ma, and our research editor, Susan Massey. Also to the wonderful staff at Duke Law, to Dana Norville, Susan Manning, Jerry Siebert, Francis Presma, Tanya Wheeler-Berliner, Catherine Hall, and Karen Ritter for all your help in making this event possible. When we met about a year ago as our board to decide upon this year's topic, we settled on public health rather quickly. The body is, of course, of central concern to our journal, how we experience life in a particular body, in a particular space, in a particular time, the assumptions we make about certain bodies, the judgments, and the laws and policies we then make based on those assumptions. Some of us arrived at public health because of a particular interest in reproduction or a particular interest in living with a disease. Some of us because of how it intersects with socioeconomic status, how it affects those who have the least among us, and how this again intersects with gender, race, and ethnicity. Some of us, indeed most of us, came from Professor Richmond's healthcare and policy class. But while some of us were grappling with the enormous complexity of US healthcare reform for the first time, at least one of us, from a medical background, questions of this import were simply a part of normal discourse. Our panelists, too, come from different places and will speak on different issues. One looks at how a particular instance of living with a disease intersects with another place of vulnerability. Another will revisit a question she has addressed earlier, and though her answer may be similar, it reminds us of the need to continuously revisit and revise questions of public health. Some panels will look to the public health of a large and diverse community, while others will look at the health of those the community often ignores and indeed tries not to think about. Our last panel looks at the way we structure healthcare, how the way we structure healthcare and payment systems in some dictate and constrain our approaches to public health. Another will construct another constraining form, language, and the traditional law review article, because how we talk about these issues limits the solutions we can see. Similarly, our audience members come from different places, from Duke and from UNC, from a researcher at the World Health Organization to someone working in mental health. We think it is important to come from all of these places. And we thank you for coming and being part of this dialogue with us today. I will now introduce Jen Ma, who will begin the next panel. Thank you.
Thank you, Eugenie. My name is Jennifer Ma, and I'm the current note editor for this journal. I believe this will probably happen throughout the day, but I wanted to begin by thanking Eugenie for the incredible work that she has done for putting together this symposium. She has managed to coordinate everyone on the journal and deal with scheduling conflicts, snowy weather, flight delays, and numerous other unknowns and uncertainties, and she's juggled it all with grace and attention to detail. So thank you, Eugenie. It is my pleasure to introduce the first panel of the day, as well as our esteemed moderator for the first and second panels of our day, Professor Kim Blankenship. Our first panel is themed around the idea of, quote, irrational women, and will focus on the public health components of abortion and infanticide. I don't know, I guess our third panelist was delayed by the aforementioned snowy flight delay, so we are going to have her speak a little during lunch. And she will speak on prenatal drug use, and that is also thematically part of this first panel. To moderate, we are lucky to have with us Professor Kim Blankenship from the Department of Sociology here at Duke and the Duke Global Health Institute. Previously, Professor Blankenship served on the faculty at Yale University's School of Public Health, where she was the Associate Director of the Center for Interdisciplinary Research on AIDS. Here at Duke, Professor Blankenship oversees the Gender, Poverty, and Health Strategic Research Initiative as part of her work at the Duke Global Health Institute. Her research focuses on race, class, and gender analyses of health, with a particular focus on HIV and AIDS. Some of her current research projects include analysis of community-led structural interventions to address HIV risk in female sex workers in India, a study of the impact of the criminal justice system on HIV risk among drug users in Connecticut, and an analysis of the relationship among incarceration, policing, and race disparities in HIV and AIDS. Thank you for joining us, Professor Blankenship, and I will turn it over to you.
Welcome, everybody, and welcome to our first panel, Irrational Women, the Public Health Components of Prenatal Drug Use, Abortion, and Infanticide. So it's my job, pretty easy actually, to introduce our speakers and keep the session rolling so that we have some time after they've talked to have questions from the audience. And I've told our panelists they don't have quite the same time crunch as we had before because one of our panelists is missing. So what we'll do is we'll allow the panelists to speak, and then we'll take questions for both of them afterwards. So let me begin by, I'll introduce each speaker in turn, and let me begin by introducing our first speaker, Manian, who is an associate professor at the University of San Francisco School of Law. She's been a Fulbright scholar in India, studying India's domestic violence law, a law clerk to Judge James R. Browning of the United States Court of Appeals for the Ninth Circuit, a Blackman Fellowship attorney, an associate at Howard Rice, Nemirovsky, Kennedy, Falk, and Rabkin, and a deputy attorney general for the California Office of the Attorney General. Her research interests include constitutional law, gender inequality, and reproductive justice. Her talk today is entitled The Irrational Woman, Informed Consent and Abortion Decision-Making After Gonzalez versus Carhart.
Thank you. Thank you, everyone, for being here so early on a Friday morning. It's my pleasure to be a part of this symposium. As mentioned, my article focuses on the question of how the law treats women as decision makers in the context of abortion decisions. And I began thinking more about this question of the law's view of women's decision-making capacity after the Supreme Court's decision in Gonzalez versus Carhart. Carhart upheld the federal so-called partial birth abortion ban without an exception to protect women's health. The federal abortion regulation at issue in Carhart purports to ban a method of second trimester abortion used pre-viability. It's called partial birth abortion by its proponents. Partial birth abortion, though, is not a medical term. It is a political term. The medical term of the method of abortion that is purported to be banned is called intact D&E. And all of the lower courts, there were 6 federal courts in all who looked at this statute, and they all found substantial medical evidence that intact D&E is medically necessary to protect women's health, at least in some cases. So the federal abortion ban does not ban all methods of second trimester abortion, but it bans the safest method of second trimester abortion. Now, women seeking second trimester abortions represent the most vulnerable group of women. Studies show that these women are the very sick, the very poor, and the very young. And for various reasons, these women's abortion decisions get pushed later in the pregnancy. In Carhart, the Supreme Court, for the first time, adopted the anti-abortion movement's woman protective anti-abortion argument. The woman protective anti-abortion argument claims that banning abortion protects women's mental health. So specifically, this woman protective anti-abortion argument claims that women don't have the capacity to make informed choices about abortion. and that women will inevitably suffer psychological health damage as a result of abortion, because abortion goes against their nature as mothers. So one of the court's justifications in Carhart for its decision was that we need to protect women from their own bad decision-making. So basically, the court stated that, although admittedly there was no reliable data to support this claim, women will regret their decision to abort, quote, because, quote, respect for human life finds an ultimate expression in the bond of love the mother has for her child, end quote. Now, there are a lot of emotional medical decisions that adults can make, and a lot of healthcare decisions that people may regret. But is that ever a reason for government to be able to ban a treatment that medical science has concluded is in fact medically necessary? Carhart's woman protective strand of reasoning got me then thinking about, how does the law treat patient decision-making outside of abortion? That is, are there other situations where the law accepts the notion that government should make decisions for patients because patients don't know what's best for their own health care? Or does that rationale only apply to women's decision-making? So my argument in the paper is that compared to how the law treats all other patient decision-making, abortion law treats women differently, and more precisely, it discriminates against women by treating them as less capable decision makers than other competent adults. And I think it's important to show that abortion law is out of step with the law on medical decision making, in part to counter Justice Kennedy's contrary suggestion in Carhart, but also to support the argument that many feminist legal scholars have made that sex discrimination underlies abortion regulations. So that's the conversation I'm hoping to add to by using an equal treatment frame to critically analyze this woman protective anti-abortion reasoning. Carhart is important because it uses this woman protective argument to justify denying women a health exception to an abortion restriction. Since Roe versus Wade, the court has always required that abortion regulations contain exceptions to protect women's health, even post-viability. That had always been the requirement until the Carhart decision came down. So this new woman protective anti-abortion argument is particularly troubling because it's meant to make endangering women's health easier to swallow by framing abortion bans as public health measures designed to protect women's mental health and to protect women's right to informed consent. And courts and legislatures are increasingly using this new public health frame to restrict access to abortion. And so in some ways, Carhart sent a message to the states that, well, you can use this label of informed consent and this frame of public health to enact more restrictive abortion legislation. So I'll just give two quick examples. South Dakota, for example, the Eighth Circuit recently upheld a South Dakota informed consent to abortion law that requires doctors to read a morality script to their abortion patients that contains really no medical information as part of the informed consent process. Another recent trend has been the passing of mandatory ultrasound laws, such as in Oklahoma, where abortion patients would be forced to undergo clinically unnecessary ultrasound, so where there's no clinical medical reason to undergo an ultrasound. Abortion patients will be forced to undergo ultrasounds against their will in order to get an abortion, again, under the guise of informed consent type of legislation. So there has been a long history of denying or diminishing women's capacity for sound healthcare decision-making in abortion law, but I'm just going to focus in this talk today on this recent woman protective turn in the Carhart decision. I'm going to compare Carhart's view of women's decision-making to the law on patient decision-making more generally, and try to demonstrate that abortion law discriminates against women because the law only subjects this gender-specific decision to this particular kind of doubt about patient decision-making capacity. So I look at two areas of law that deal with patient decision-making. From the perspective of private law, that is the tort law doctrine of informed consent, we generally treat competent adult patients as having the capacity to make their own medical treatment decisions. So we allocate decision-making authority to the patient rather than to the physician. So I look at informed consent law in part because Carhart misuses the rhetoric of informed consent, and I want to disentangle informed consent as used in abortion law from the tort law doctrine, and show that abortion law unjustifiably diverges from the tort law principles underlying informed consent. Also, from the perspective of public law, so constitutional law, we do sometimes allocate decision-making power to the government rather than the patient when the government has an interest in overriding patient decisions, arguably for the sake of public health. But I argue that the woman protective anti-abortion argument finds no support in these constitutional law precedents on medical decision-making. Basically, in no other area of healthcare law does the state override a competent adult's right to consent to medical treatment that falls within the bounds of proven and accepted medical practice and is in fact physically safer for the patient based on the state's view that the treatment will be psychologically harmful to the patient based on these unsubstantiated concerns about patient regret. So we're here, the government is imposing physical health risks on patients supposedly to protect them from the harm of regret. And in contrast to both private and public law on healthcare decision-making, Carhart treats only competent adult women as incompetent to make a decision about a procedure that is proven to be effective and safe and is in fact the safest procedure available. Basically, the court allows the government to act as a surrogate decision-maker for women as if women were children or insane persons who needed one. So let me start then with a brief overview of the law of informed consent. In principle, at least, the law of informed consent rejects a paternalistic model of patient decision-making, where the physician makes treatment decisions for the patient. Instead, it enshrines into law a model that says competent adult patients have the capacity to make their own medical treatment decisions. Now, if we applied this model of patient decision-making to abortion law, we would see some very different results. So I think it's useful to use informed consent law as a lens to critique abortion law, first to show the misuse of informed consent terminology in abortion law, and second, because the contrast between the two areas of law shows quite clearly that abortion law treats women as not so capable, as less capable decision makers in comparison to how healthcare law generally views patients. There's about a century of history of development of informed consent law in the US. Early case law on informed consent treated the issue as it was an assault or a battery. It was an unconsented contact, and that was the problem with it. And under the battery theory, the primary concern is protecting the patient's bodily integrity. You have a right to say who gets to touch your body. Courts later also recognized a claim for negligence, a malpractice claim, for failure to disclose the risks, benefits, and alternatives to a particular treatment. And under the negligence theory, for a failure to disclose rather than for unconsented contact, the primary concern is protecting the patient's decisional autonomy or self-determination. One of the leading cases on this topic, Canterbury versus Spence, articulated the core principle like this, quote, "It is the prerogative of the patient, not the physician, to determine for himself the direction in which his interests seem to lie." So even though the physician has the medical knowledge, you are the most capable to decide what's going to be best for you in your individual case. And there's a rich literature on informed consent and a lot of debates about how it works in practice, what its purposes really are, but just the general notion that competent adult patients have the capacity to be self-determining in healthcare decision-making is very well entrenched through this law of informed consent. And informed consent is basically designed to enhance patient autonomy. But when you compare this law of informed consent to abortion law, there is a stark difference in how the law views women's capacity for decision-making. Abortion law claims to protect women's right to informed consent, but in fact, it fundamentally contradicts informed consent's core principles. So I'm not going to go through the whole history of abortion law, just a quick summary. For a period of time, under the Roe versus Wade framework, the law treated women as equally capable decision makers. So informed consent to abortion and informed consent to any other kind of medical treatment were the same. The rules were the same, they were parallel to each other. But abortion law's view of women's decision-making capacity has been diverging from informed consent law's view of patient decision-making since the Supreme Court's decision in Planned Parenthood versus Casey. Casey started to veer off in a different direction, and then by the time we reach Carhart, the court basically denies women's capacity for decision-making entirely. So let me just talk about Carhart. There's a lot to say about the Carhart decision. It makes a number of significant changes and really reverses some key aspects of the abortion right. But I'm just going to focus on the court's woman protective rationale for upholding the federal ban on intact DNA. Carhart invokes the government's interest in protecting patients' right to informed consent as a reason for the federal ban. So the court says, quote, in a decision so fraught with emotional consequence, some doctors may prefer not to disclose precise details of the means that will be used, confining themselves to the required statement of risks the procedure entails. It is, however, precisely this lack of information concerning the way in which the fetus will be killed that is of legitimate concern to the state. The state has an interest in ensuring so grave a choice is well informed, end quote. So with this language, Justice Kennedy is invoking patients' right to informed decision-making. We should be well informed before we make significant medical decisions. But more disclosure would be the obvious solution if the government was really concerned about lack of information. Why not just require then disclosure of the details of the procedure? Instead, the court uses informed decision-making as a reason to deny patient autonomy rather than to enhance patient autonomy. So just contrast, for example, some recent studies on prostate cancer treatment. Studies have shown that 1 in 5 men regret such treatment because it reduces sexual function. So it's an emotionally fraught decision for men, but the medical and legal response, because some men do regret their treatment, is not to ban this medically necessary treatment, but it's rather to provide all men with more and better information so patients can make better decisions. That's the usual solution to the problem of lack of information. So why does the court reject that option, which Casey would permit? Casey sort of opened the door to much more detailed abortion-specific informed consent laws. So here's what the court says. Quote, while we find no reliable data to measure the phenomenon, it seems unexceptionable to conclude some women come to regret their choice to abort the infant life they once created and sustained. Severe depression and loss of esteem can follow. Now, in fact, a recent report by the American Psychological Association confirmed previous studies that have consistently shown that most women do not suffer psychological harm post-abortion. Nevertheless, the court says, quote, it is self-evident that a mother who comes to regret her choice to abort must struggle with grief more anguished and sorrow more profound when she learns only after the event what she once did not know. So I emphasize that contrary to Carhart's characterization of what it means to ensure well-informed decisions, informed consent law rejects the idea that patients cannot balance the risks and benefits of medical treatments and determine where their best interests lie. The woman protective reasoning is really fundamentally in opposition to informed consent principles. It incapacitates competent adult women and denies women's ability to know what decisions are in their own best interest, and it does so solely based on sex role stereotypes. The court's justifications for its conclusions are admittedly not evidence-based. The court admits it has no reliable data, but it says it's self-evident how a woman would feel about this decision, and that's because of archaic notions about women's irrationality, their emotional nature, and their nature as mothers. And Reva Siegel, a Yale law professor, has extensively demonstrated the gender stereotypes inherent in this women protective anti-abortion argument. But if you read the decision, you'll see that Carhart portrays women, particularly mothers. It repeatedly refers to women seeking abortion as mothers, even though they're seeking not to be mothers at that point. These women are too emotionally unstable to make significant decisions. It characterizes pregnant women as sort of hysterical and childlike. And it also implies that women's role as mothers mandates that they sacrifice themselves for their fetuses, or else they're going to become psychologically unstable. It treats pregnant women who make decisions judged to be contrary to their ultimate role as mothers as insane. Jack Balkin said what the court says is either a woman is crazy when she undergoes an abortion or she will become crazy later on. And what Carhart really does is it parades as a description what is in fact a normative judgment about the appropriate role of women. So again, I think this divergence between informed consent law and abortion law exposes abortion law's discriminatory view of women as decision makers. But to flesh out a fuller comparative model of the law's view of patient decision making, I also had to look at constitutional law precedents on medical decision making. And I argue that Carhart's reasoning finds no support even in the limited instances when government can override a patient's right to informed consent for the sake of protecting public health under these sort of public health constitutional law decisions. And so this is where it gets kind of interesting. The implication of Carhart's woman protective reasoning is that Congress's purpose in banning intact D&E is the legitimate purpose of protecting maternal health. So one of the things Kennedy seems to be trying to do in the opinion is frame these abortion bans or any type of abortion restrictions as a public health issue and suggest that, like other public health precedents, the court should leave it to the legislature to determine what is best for the public health. So I look at 4 general areas where the U.S. Supreme Court has allocated decision-making power to the government rather than to the patient under this banner of public health. And the 4 areas that I look at in the paper are compulsory vaccination laws, bans on controlled substances, such as medical marijuana, regulation of experimental drugs, and bans on physician-assisted suicide. And what I argue is that none of these public health cases ban a medical treatment that is proven to be physically safe on the reasoning that the government's unsubstantiated view that the treatment will be psychologically harmful to the patient justifies imposing these physical harms. So none of the cases say that the government knows better than a mentally competent adult what will be best for their mental health. That kind of paternalism only applies to women patients seeking abortion. So I argue that these few exceptions where the Supreme Court allows the government to force or ban a medical treatment option to diverge from the informed consent model are all distinguishable from the woman protective reasoning used in the abortion context. And I think demonstrating that this woman protective reasoning doesn't find support in existing precedent it contradicts what Kennedy says in the opinion and also supports my argument that this reasoning in abortion law is an anomaly in the law's treatment of patient medical decision-making. It is discriminatory treatment of a gender-specific decision. Now, the easiest public health precedents to distinguish are the cases where the government denies patient choice on a for the common good rationale rather than a paternalistic this is for your own good rationale. So I divide it into those 2 different rationales. So the for the common good rationale is where compulsory vaccination laws and bans on controlled substances fall. So compulsory vaccination, bans on controlled substances are primarily justified on the grounds of protecting third parties other than the patient for the common good of the public. So in a nutshell, the government can protect the public from communicable diseases and from the harms of recreational drug abuse, and that's why we can deny patient choice in those circumstances. I explain those more in the paper, and I can talk about that a bit more during the discussion. But really, the harder con law precedents to distinguish from Carhart are the ones that, like Carhart, offer a paternalistic, this is for your own good rationale for government limits on patient choice. So I'll just focus on these harder cases, which are the regulation of experimental drugs and bans on physician-assisted suicide. So with the federal government regulation of experimental drugs, patients have tried to assert a right to access experimental drugs not yet approved by the FDA. And the Supreme Court has justified government restrictions on experimental drugs in part on the ground that the regulation is for the patient's own good, that government is doing this to protect you, the patient, from your own bad decision making. So the justification accepted by the courts for allowing the government to limit access to potentially life-saving experimental drugs is that there is a lack of information here such that the informed consent model of patient decision-making won't function properly. So when it's a novel, untested drug, the government needs to step in as a decision maker and information gatherer on the patient's behalf when the patients otherwise can't get the information on the risks and benefits of novel drugs. So that's one reason it's a little different. We don't have the information here, so we can't really use informed consent. But also, the courts emphasize that without this regulation, patients could be subject to risk of severe physical harm from using untested drugs. And the courts relied on actual evidence of such physical harm, severe harm, occurring in past cases. And Carhart is clearly distinguishable because the federal ban on intact D&E denies access to a treatment proven to be safest based on established medical knowledge on the ground of protecting women's emotional health. So here, the government is imposing known physical health risks on women patients to prevent an unsubstantiated risk of psychological harm. So regardless of how you feel about the regulation of experimental drugs, Carhart presents a kind of paternalism and a denial of women's decision-making capacity that is not supported by allowing government restrictions on novel and untested medical drugs and devices. The last of the common law precedents I look at is the physician-assisted suicide ban. That precedent arguably supports the woman protective anti-abortion argument that was in Washington versus Glucksberg, that the Supreme Court rejected the argument that competent adult terminally ill patients have a constitutional right to physician-assisted suicide, to seek physician-assisted suicide. This, I think, is the hardest precedent to distinguish from Carhart, since it is arguably as thoroughly paternalistic as Carhart's reasoning, right? Here, also, the government is denying a competent adult a choice in order to, some say, protect the patient from their own poor decision-making. And Kennedy relies very heavily on Glucksberg to support his reasoning on Carhart. But I argue that Glucksberg's justifications differ from Carhart's woman protective reasoning in several ways, so that Glucksberg really doesn't support this particular woman protective line of reasoning. First, the court reasoned in Glucksberg that bans on physician-assisted suicide, that at least a number of justices said that one of the main reasons we should ban physician-assisted suicide is that it protects the lives of mentally incompetent patients and patients subject to coercion. So the rationale is really that it protects third parties other than the competent adult patients making voluntary decisions. And the problem is, in practice, it's hard to differentiate between those who are competent and those who are not, and those who are making voluntary decisions and those who are not in this context. It was a fear of a slippery slope that was based, again, on some actual evidence of such problems occurring in other countries. So it falls into the more like the protecting third parties rationale, the for the common good justification for denying patient choice, at least to a certain extent. Second, the ban on physician-assisted suicide, or at least the denial of a constitutional right nationwide to physician-assisted suicide, is that it protects patients from the gravest of physical harms. It protects patients from an unwanted death. Whereas in Carhart, it seems like a different order of paternalism to protect patients from this admittedly unsupported fear of regret of their decisions. Not least because informed consent law clearly establishes the opposite principle, that patients know best what decisions they will least regret. There will always be some patients who will regret any decision, but in no other case is that a justification for banning that treatment for everybody. Additionally, I think that the woman protective argument, anti-abortion argument, is particularly troubling because it is steeped in gender stereotypes, and it's steeped in gender stereotypes that have long been rejected under equal protection jurisprudence. Now, the Glucksberg opinion also rests on assumptions on stereotypes about terminally ill patients. Glucksberg expressed a lot of concern about the decision-making capacity of dying patients due to the vulnerability and dependency that often results from becoming very, very sick. But even if we assume that the rationales in Glucksberg and Carhart are similarly paternalistic towards patients, the assumptions in Glucksberg applied equally to all similarly situated patients, to all terminally ill men and women seeking physician-assisted suicide. Now, rightly or wrongly, our equal protection jurisprudence does not offer heightened scrutiny for stereotyping based on disability, poverty, or age, but does apply heightened scrutiny to government actions that are gender-specific or motivated by gender stereotypes. So Glucksberg certainly does not support the gender-based paternalism animating Carhart. Now, I'm not arguing that the ban on upholding bans on physician-assisted suicide is right. I don't think I have to argue that denying a right to physician-assisted suicide is the correct decision to say that this woman protective reasoning is wrong. My point is mainly that abortion is the only case where the government can endanger patient health in order to protect the patient from an unfounded risk of regret due to the patient's own supposedly bad decision-making. That's where we can really see the gender discrimination in the law. So in conclusion, I just want to briefly talk about this notion of mothers as incompetent decision makers and sort of why focus so much on this woman protective strand of reasoning in Carhart. It is just one strand of reasoning in the decision. But in many cases, what the Supreme Court says matters as much as what the Supreme Court does. And when the court is going to put its imprimatur on these kinds of arguments about women's decision-making capacity, it reinforces stereotypes, and it makes courts and legislatures feel freer to follow those kinds of stereotypes. And within abortion law, we can already see the effects that this reasoning in Carhart has had. It's already had a significant impact in the courts and in the public arena, exhibited particularly by legislatures enacting abortion-specific so-called informed consent legislation, like the examples I mentioned in South Dakota and Oklahoma. And as media stories reported, it's sort of the legal and political battles over abortion are now framed less as, well, what's going on in the woman's womb, and more as what's going on in women's head. Can we really trust women to make these decisions? And I wouldn't be surprised to see this logic extended to other areas that have been generally labeled maternal-fetal conflict, such as pregnant women's right to refuse life-saving treatment, forced cesarean sections, and punishment for drug use during pregnancy. And there are already quite a few cases dealing with these maternal-fetal conflicts, or as Michelle, I think, has more accurately labeled them, maternal-doctor conflicts. And many of these cases already play on the notion that women are irrational decision makers, particularly women of color. So the way that Carhart portrays mothers as poor decision makers has serious implications not just for abortion rights, but for the legal regulation of motherhood and the legal regulation of pregnant women more broadly. And so at least one way, perhaps, to counter the force of this woman protective claim would be to recognize that the woman protective argument for restricting pregnant women's decision-making is an anomaly in the law's treatment of patient healthcare decision-making, and that it violates women's right to equal treatment under the law. So I'll end there.
Thank you for a really interesting presentation. Our second and last panelist is Michelle Oberman, who's currently professor of law at Santa Clara University School of Law, where she specializes in examining the intersection of women's health, poverty, criminal law, and public health issues. She's a former chair of the American Association of Law Schools section on law and medicine, and she maintains various affiliations with different healthcare organizations. In her current research, she uses ethnographic methods to develop a cross-cultural understanding of women's health and the law, which is reflected in her talk today entitled Eva's Baby, a narrative essay on the public health components of infanticide.
Hi, good morning. I've been working on the subject of mothers who kill their children in one form or another for over 10 years. I've written law review articles, book chapters, a couple of books, and still I find myself met by questions from those who've read my work, those who've skimmed it, those who've fallen asleep trying to read it. Questions like, how could she have done this? And then the unarticulated question of, could this have happened to me? So I wrote this essay in an effort to answer those questions for myself and perhaps to generate a broader sense of why I think it happens and whether it could have happened to me or perhaps to you. My grandmother Lillian, may her memory be for blessing, used to say, "You could be dying of cancer, but if my little pinky hurts, it's all I can think about." We thought she was a narcissist, albeit a self-aware one. Of late, I've come to wonder whether her condition was congenital, or maybe even endemic. It's like that quote from Aeneas Nin, "We don't see things as they are, we see them as we are." I want to tell you the story of how I've come to see a woman called Eva. It's more than just Eva's story, which is interesting in itself. It's also my story, puny like a pinky. The story starts on a frigid February morning in 1992 when my friend Jack, a criminal defense lawyer with a solo practice in downtown Chicago, called to talk with me about his 16-year-old client, Eva, who had hidden her pregnancy from her family and then given birth in a toilet. Her case was going to trial. He had never heard a story like hers. Oddly enough, I had. 3 years earlier, in my first year of teaching, I was sitting in my office grading memos from my legal writing students when I got a call from a Will County defense lawyer just south of Chicago. The lawyer called because she mistakenly believed the Institute for Health Law, where I worked, might have the sort of expert who could help her explain to a jury why her 14-year-old client hadn't told anyone she was pregnant and had delivered her baby into the toilet. The girl never had sex education, she said. They don't teach sex ed in Will County. She'd only gotten her period once, the lawyer added. I listened to the slow whish of her breath in and out through the receiver. She sent her dad out for some aspirin while she sat in the bathroom. She thought she had cramps. When her dad got home, he found her passed out on the bathroom floor. The lawyer paused again and exhaled into the phone. Her dad said there was blood everywhere. He called the EMTs. They found an 8-pound baby dead in the toilet. I could tell the lawyer believed this girl was not a murderer. Although I'd never heard anything like it before, I instinctively agreed. In those days, I volunteered once a week at Planned Parenthood, talking teenagers through pregnancy tests and helping them identify options. I had not yet had my babies, had never even been pregnant. Some girls brought their boyfriends with them, but most came alone. Pregnant or not, most girls wept. We sat in hard chairs at the table in the tiny yellow counseling room, staring at the future foretold in the plus or minus on their plastic pregnancy wands. I felt sorriest for the young ones, those who were 13 or 14 and had little idea how a baby would shape their future. As often as not, they preened in pink-faced delight at their positive pregnancy test, amazed at what their bodies had done, dreaming of the future they would share with their absent boyfriends, their babies' fathers. More than once, excited at learning they were pregnant, these girls looked up in concern and asked, "Are you going to tell my parents?" I collected their stories like souvenirs, fingering them in my mind as I rode the L train home to the dingy apartment my husband and I rented just north of the city. Unlike the girls I met, I had a pretty clear sense of the love and stability I expected to have in my life when I became a mother. What I didn't know was how I was going to get there from where I was on the cusp of 30. Nothing was going according to plan. My marriage was coming apart. I had no job security, an adjunct teacher's salary, and all my law school debt. I should have been paying those Planned Parenthood girls for what they gave me. They looked at me across the counseling room table as though I had the answer, as though the decisions I'd made had come out all right, as though I was there already. I told the lawyer from Will County I would try to find her an expert. A week later, she called back. She didn't need an expert to explain her client's actions after all. Her client had pled guilty to involuntary manslaughter. The prosecutor subpoenaed the boys from the 8th grade class, she said. They told him they used to line up outside her bedroom after school and take turns having sex with her. She didn't want to face them at trial, so she took the guilty plea the state offered her. The judge sentenced her to probation and counseling, which, her lawyer said, probably was the best thing for her. The case was over. Although I wondered about the story from time to time, my life moved on. When Jack called me that February morning 3 years later for help with Eva's defense, I was a full-time professor, teaching health law at a local law school. He needed to explain Eva's story to a jury. The only way I could think of helping was to introduce him to a woman I taught with, Molly Gruder, the head of obstetrics and gynecology at Cook County Hospital. All of her patients were poor women and girls. Maybe she'd understand what Eva had done and why. County Hospital was a hulking structure, since condemned, on the city's near west side. Molly met us in the lobby where, after work, uninsured mothers and their crying babies lined the eggshell-colored benches of the waiting room, eating dinner from the single vending machine. At 35, Molly was one of only a handful of U.S.-born doctors in her department. Stocky and wearing dull green scrubs, she seemed matronly in spite of her youth and her political edge. This country, she said, nodding at the waiting patients as she steered us toward her office, this country has a penchant for blaming individuals for societal ills. Jack told her about Eva's case. "Oh, we get girls in here all the time who don't know they're pregnant," Molly said. "Someone will bring them in here in full-blown labor, thinking they're having a real bad stomachache. Sometimes they wait until after the baby is born, and in comes the aunt, the grandmother, the teenager, and her new baby. One of the nurses adopted a child from a family who came in that way." Jack asked Molly to testify at Eva's trial. He liked her tone. She was compassionate and professional, and she would help him persuade jurors that Eva was not a monster, but a girl. Criminal law is not subtle, it's efficient. All the state needed to prove in order for Eva to be guilty of murder was that she had committed a prohibited act, an actus reus, such as drowning her newborn baby, and that she did so purposely with mens rea. Legally, it didn't matter why Eva didn't tell anyone she was pregnant. She could be guilty even though she was ashamed she had had sex, believed abortion was murder, and was convinced her family would throw her out if they knew she was pregnant. It didn't matter that her boyfriend of 2 weeks had left her when she told him she'd missed her period, or that Eva had cried for them to bring her the baby afterwards when she lay in the emergency room. The trial went forward. I watched from a seat toward the back of the crisp, pine-paneled suburban courtroom as the pregnant prosecutor pointed at Eva and said, "This girl has committed the vilest of crimes known to man." Eva sat shrunken and pathetic beside Jack in his tailored suit at the narrow counsel's table. Her long brown hair covered her eyes, her shoulders hunched under her baggy blue button-down shirt. The jury convicted Eva, but not of murder, which would have meant decades behind bars. Instead, she got only involuntary manslaughter and probation. "A victory for the defense," said Jack, as these things go. Her story ended without her ever really telling it. Long after the trial was over, thoughts of Eva and her baby still festered in me. Why didn't she tell anyone she was pregnant? Was she like the girls I'd met at Planned Parenthood who wanted to keep their pregnancies secret from their parents? Was she just a bit more broken than they were? Or was she completely different, keeping her secret as if she was playing a game of chicken, headlights off, running her car blindly into the future? And under it all, there was a question I couldn't begin to answer. Could it have happened to me? At the time, these seemed like academic questions, so I began studying the subject of mothers who kill, finding scattered books and articles about infanticide in medical collections, historical records, and social science journals. I found research about abandoned baby girls in China, about drug-addicted mothers whose babies were born stoned and shaking, about postpartum psychosis and mothers who threw their babies in oncoming traffic. None of these stories shed any light on why Eva had killed her baby. I knew there were other cases like hers, though, so I turned to newspapers and magazines. The internet was in its infancy in 1994, when I started collecting journalists' reports about girls like Eva. I searched for articles that mentioned pregnancy within 10 words of toilet or dumpster. It was easy. I found 97 stories in the first few months alone, but none of them discussed why these girls hid their pregnancies. None of them explained why they did it. I had some hunches about Eva's story, but they weren't the sorts of things I knew about from books. Eva must have been terrified to find herself pregnant. Anyone who's ever been late 1 month can tell you as much. Fear is part and parcel of unplanned pregnancy, if only because it brings change upon you, demanding your attention. The official story was that Eva ignored her pregnancy. Like her jury, I rejected the vision of Eva as an intentional killer who chose to look away because she wanted her baby to die. Still, it seemed hard to believe that fear alone would have paralyzed her for those many long months. Things in my life, my own puny story, told me the truth had to be more complicated. By the fall of 1995, my first marriage was long over. My new partner Leo and I had been living together for 2 years, first in the small, square house with the backyard perfect for wiffle ball, and now in a too-big grown-up house with a long living room. The windows looked out on a patch of community gardens next to a wriggling branch of the Chicago River. Sundays, when Leo's kids were with us, we played football on the lot between our house and the gardens. The kids stayed over on Saturday nights, 13-year-old Rebecca in her own room, which she decorated in blacks and purples, and Michael and Joey, 11 and 7, in the red and blue train room decorated by the doting mother who used to live here. We set up a computer on Michael's desk and loaded it with games, but mostly we hung out in the living room, watching the light recede and listening to Leo sing along with the sad songs he played on our CD player, which sat on the floor in the corner. After we took the kids back to their mom's house, Leo and I sat on the sagging couch facing the dark window. The only thing visible was the traffic signal over the busy street that separated our house from the creek. Because our street had less traffic on it, the light was mostly red. "We need to talk," I said into the darkness. At 34, it seemed like every passing month was a missed opportunity. More days than not, I lived in quiet panic. "I can't believe you're going to bring this up now. It was a beautiful day. The kids were happy. We went for a long walk. They love you. Why can't you just let it be?" He retreated into silence after I screamed, "If you're still unsure, why don't you get a vasectomy?" I was afraid to leave Leo and have a baby on my own. I was afraid staying with him meant I'd never experience the connection I craved, a baby's perfect love growing in my belly. Meanwhile, 3 years after Eva's trial, I had read everything I could find about mothers who kill their children, and still I didn't really understand what had happened to her. I asked Jack if he thought Eva might talk to me. Jack suggested we meet for lunch. Eva spotted Jack as she came through the hot dog stand's door, and walked over to us. She was wearing a sweatshirt, hood over her head, even though it was as glorious as it could be, a blue sky fall day. Everything about her seemed average to me, her height, her weight, even the hue of her straight hair, not dark, not light, just plain brown. Jack made the introductions, talking fast. "Eva, this is my friend Michelle. She's doing research on girls who kill their babies. You know, like..." He faded out. Eva didn't flinch. She sat across from me, slouching in the plastic chair, her hood still up, her eyes on the white plastic table. When Jack had called to ask if she was willing to meet with me, Eva said she had never told anyone about what had happened. Her probation terms had not included counseling, and as for her family, no one had asked her. Not her mother, nor her father, nor her stepmother. Not her uncle nor his fiancé, with whom she'd been living when it happened. Not her grandparents, who had not been at the trial. Not even her best friend, who had been with her in her secret daily life then, and who was with her still. Eva sat without moving, waiting for me to begin questioning her. In the background, there was a low buzz of conversation from customers in line. Cashiers called out order numbers as they slid plates along the stainless steel counter. There was an insistent pulse of tuneless music coming through the overhead speakers. Everything sounded distant and blurry, as if we were underwater. I didn't have much of a plan, but we had both come to hear her story, so I began. "Where were you living when you found out you were pregnant?" I asked. Jack went to buy her a Coke and a hot dog. Her eyes still on the table, Eva started slowly. "I was living with my grandparents first. Maybe it was the winter of my sophomore year. We were fighting a lot because they were just different. Like, they don't really speak English, and so my uncle told me to come and live with him and his girlfriend." Eva's voice was quiet and flat, every word delivered in the same tone and at the same pitch. I looked away from her and plunged. "What about your mom? How come you weren't living with her?" "She was busy. She had my 2 younger sisters and my stepdad, and it was a small place, and I was always having to babysit, so I went to live with my grandparents." "Did you want to?" "Well, it was okay. How old were you when you left your mom's?" 14. Eva looked at me. She seemed puzzled by my curiosity about these details. I was thinking about her mother, judging her for having sent Eva away. So where did you go after you left your grandparents' home? I asked my dad and stepmom if I could live with them, but they said it wouldn't work. They had a new baby, so I was staying at my friend Clara's apartment for a few months. But then Clara's mom wanted to get some money from my mom to pay for things for me, and my mom said no, so after that I went to stay at my uncle's. Her dad and her mom both said no? Of the recurring themes in Leo's and my ongoing struggle over whether to have a baby, the most common was his guilt about having abandoned his 3 kids. In accord with his divorce decree, he got to see the children every Wednesday evening and from Saturday night until late Sunday. When we decided to live together, Leo and I limited our search to a 10-minute drive from their mother's house. By 7 p.m. on Sundays, no matter how much fun we'd had, his middle son, Michael, always got quiet. Is it the dinner? What, you don't like my curry? I'd ask, trying to prod him into smiling. We'd wait until the last minute to get into the car and return them to their mother's place. No one ever spoke on the ride back except me. Waiting outside until we saw the porch light switch on and her door open and close, Leo and I sat, breathing the thick car air. I loved them from the beginning, my stepchildren, and yet I wanted more. Every month I felt a new egg ripen in me, yearning, insistent. I can't keep waiting like this. My eggs are growing old, I told Leo one Sunday when the kids were upstairs. Don't leave, he said. I'm just not ready to talk about it yet. Wait until December when work settles down. We'll talk then. I was furiously quiet that fall. Eva said she got pregnant toward the end of winter in early 1992. She still was living at Carla's house when she met a boy from another school. We only saw each other a couple of times, she said. He was my second boyfriend. I looked at Eva. I didn't need to ask why she hadn't used contraception. I couldn't imagine her stopping him, let alone asking him to put on a condom. So did you know you were pregnant, I asked? Yeah, and then I told him and he offered me money for an abortion and I said no, and so we just never talked again. Why didn't you want an abortion? I don't know. Eva told me her 16-year-old cousin had had a baby the year before. Don't be a fuck-up like Lauren, her relatives occasionally warned her. Once, when Eva was several months pregnant, Eva asked her mother how she would respond if she got pregnant. I'd kick your ass and throw you out and send you and your baby to live with your boyfriend, she replied. Eva did not have a boyfriend anymore. Her mother's words sounded like bluster to me, but Eva probably didn't feel that certainty. I kept telling them I needed a job, I needed insurance. They never asked me why. Eva did not need to conceal her pregnancy, I realized at last. Not because she was heavy, she wasn't, and not because she wore baggy clothes. No one was looking at her. In the background, as Eva spoke, I could hear the rattle of the approaching L train. I wanted to ask again why she didn't have an abortion, but I would have had to shout. The landscape of the South Loop is defined by this odd oral fact. Any conversation of substance inevitably will be interrupted, randomly, and perhaps irrevocably, when the train passes overhead. It was coming now, the loudest noise in the restaurant. Leo never let me talk about the two of us having a baby when we were alone, but the subject often surfaced when we were with our closest friends, Beth and Martin. Beth's parents had a farm an hour or so outside the city. We visited all the time. The fall days were short yet glorious in her father's newly flat field of harvested soybeans. One Saturday, Beth, her niece Mimi, and I swung on the oversized hammock out front. Golden leaves fell on us from the giant oaks that anchored the hammock. Baby Mimi giggled as we passed her back and forth between us, tickling her, sucking her toes, keeping her distracted and happy for an hour, maybe 2. It was easy. Later, we sat with Leo and Martin by the fireplace drinking hot cider. People just use children as an excuse. Their kids become a moral justification for failing to do anything meaningful with their lives, Leo said. I don't buy it, said Martin. There are plenty of people who are parents and are working to improve the world. Name one who's doing really significant work, said Leo. Name one who's a mother, said Beth. I said nothing. I didn't want to think about how having a baby would change my life. Eva and I sat quietly. The yell had passed. Jack had returned with the food, a rubber pink hot dog in its bun, relish and mustard all over it. So then you were pregnant and you moved to your uncle's house, right? Yeah, and his fiancée. Were you okay living there? Yeah, I was sort of scared of him, though. He had a real bad temper. So what did you do? I mean, day by day as time passed. I don't know. I didn't really think about it. Not really. I mean, some days I would go over to Carla's house and we would lie on her bed and she would touch my belly and ask how it felt. So Carla knew you were pregnant? Yeah, she was the only one I told. One day we were laying on her bed after school and Carla's boyfriend was over. I pulled up my shirt and showed my belly. Afterwards, she said, "Geez, you better not do that or someone's going to find out." Nobody else knew you were pregnant? Well, some people sort of guessed, like this girl in gym one day said to me, "From far away, you look like you're pregnant, but then up close, it's different." In Eva's story, the months of her pregnancy passed slowly. When I thought about being pregnant, she said, I just kept wishing and hoping someone would say something, or maybe call my family and tell them, Eva's pregnant. Late in her pregnancy, someone finally noticed. Eva's mother took her to a school nurse to get a vaccination she needed in order to begin the fall semester of her junior year of high school. Eva went into the examination room alone. The nurse looked at Eva and asked whether she had made arrangements for the baby. It was weird, Eva said. It was the first time any adult had said something about me being pregnant. I didn't know what to say, so I just shrugged. The nurse didn't ask again, and Eva left the room. Her mother must have seen something odd in her face, because Eva recalls her having said, jokingly, "What happened in there? You look like you saw a ghost." "How did you respond?" I asked. I just shrugged. "So your parents and your step-parents must have suspected something." "Well, I kept trying to get my mom to notice," Eva said, her eyes still downcast, now brimming with tears. "I kept telling her I was getting fat and putting her hand on my belly. She would just pat it and say, 'No, you're not getting fat.' Afterwards, when it was all over, my stepmom said to me, 'We sort of knew that you were pregnant, but we didn't want to butt in or anything.'" Eva's hands were folded on the table, her fingernails bitten so short that the skin popped out red and hard at the tips. I reached my hand across and let it rest on Eva's forearms. Jack shifted in his seat. He glanced at me, rolled his eyes, and shook his head lightly in disbelief. He didn't know Eva's story either. I saw Eva squeeze her eyes tightly and bite her bottom lip. I pretended not to notice her soft tears. Most of the time, the law says you're not responsible for others. There's no duty to rescue someone you see drowning, even if you're an Olympic swimmer. You're not responsible, unless, of course, you threw them into the lake. Eva's parents hadn't thrown her into the lake. They just kept on walking the beach. Parents have a legal duty to save their children, of course, but cases involving what the law calls failure to protect are about mothers who didn't stop their boyfriends from abusing their children. They aren't about parents who touch the rock-hard belly of their 7-month pregnant daughter and just say, "No, you aren't getting fat." Sometimes, though, the criminal law says you're not allowed to look the other way. If someone pays you $10,000 to drive a car over the border, for instance, and you choose not to look in the trunk, it's called willful blindness. You can get convicted of smuggling, even if you didn't know what you were sneaking over the border, because the only reason you didn't know was that you looked the other way. But willful blindness doesn't apply to the boy who gets his girlfriend pregnant and doesn't stay around to find out what she's going to do about it. I'm a lawyer, and I understand why it would be a problem to prosecute Eva's mother or father, her step-parents, her uncle, her fiancé, his best friend, her boyfriend, the nurse, or anyone else who knew about Eva's baby. It would be nearly impossible to warn people what they owe to one another ahead of time, or to decide after a tragedy who should be guilty for having failed to stop it from happening. Still, so many people had looked away from Eva that I couldn't figure out who was really to blame for what had happened. "So you just went on with your everyday life?" I asked. "Yeah, I was working with my dad and stepmom at their warehouse when I went into labor. I lay down on a couch in the lunchroom. I was feeling really bad, but I wanted to go to Carla's birthday party that night. I told them I was sick, and they put me on the bus back to my uncle's. When I got there, I started to feel like I needed to go to the bathroom, so I went, and I stayed in there all night." Eva didn't want to talk about what happened in the bathroom, about the gory stuff, as she put it. And now that we had reached it, I felt relieved. I didn't want to hear her describe the convulsing departure of blood, mucus, poop, and vomit, all the things that had held her baby safe within her for those long months. I didn't want to know whether she looked down and saw her perfect baby floating in that dark water. There had been plenty of discussion of this part of her story at trial. This was the part the law had been interested in. The prosecution's expert witness testified that Eva's daughter had been born at full term and had cried out at least once before she drowned in the toilet. An autopsy showed there was air in her lungs. Dr. Molly Gruder, the obstetrician from Cook County, described labor and delivery, the physical pain, the body's work in pushing out the newborn, the exhaustion. Childbirth is not a silent process, she said. Eva's uncle testified that neither he nor his fiancée had heard a thing that night, even though their bedroom wall adjoined the bathroom. The following morning, he said, his fiancée saw blood on the floor of the bathroom and knocked on the door of Eva's bedroom to tell her to clean it up. Jack called Eva to the stand, where she told the story of her baby's death in a whisper. She said there had been blood everywhere, all over her, on the floor and on the walls. As soon as the baby was born, she got up from the toilet and began mopping and scrubbing. After several minutes, she laid a clean towel on the floor, pulled her baby from the toilet. She wrapped it inside the towel. She carried it back to her bedroom, and she fell asleep, cradling the bundle against her body. Later that day, Carla called to see why Eva hadn't come to her birthday party. I told her my baby had been born, told her what happened, and she told her parents. That evening, the police came to Eva's uncle's apartment and asked him if they could question Eva. They found her in bed, still holding her baby's body. Moments later, Eva was arrested for homicide. The end of Eva's story didn't take long. The judge sentenced her to probation and community service rather than to the term of years he could have demanded in punishment for the jury's involuntary manslaughter conviction. After the trial, Eva said, her mom was pissed at her. She was mad that I wasn't acting grateful, so she just left me in the courthouse. I didn't know where I was supposed to go next. It was late, and everyone was leaving. Finally, I took the bus to my uncle's house. I could see Eva standing there as her mother's steps echoed down the beige courthouse corridor with its fluorescent lights and its bright green fake ferns. She would have walked outside alone to find the concrete bus shelter along the rush hour road, past the manicured lawns surrounding the parking lot, past the beds of spring annuals turning mauve in the twilight. As she spoke, I finally started crying. I cried for Eva and her unnamed baby, the one she had carried inside her all those silent months, the one whose body she had cradled all day in bed as she waited to be discovered. And I suppose I cried for myself as well, and for the dream baby I had been carrying with me in my life thick with blessing for as long as I could remember. It is so much simpler to love a vision than to contend with reality, screaming its helpless screams. Not answers, but questions. Will you? How? When? I screened Eva's face for some sign of what she was feeling. Her eyes were still glassy with tears. I don't ride the bus anymore, she said. I feel like everyone knows me, like they're staring at me. She was wrong. She could have walked past me in the crowded lunchtime streets 100 times, and I never would have noticed her. I nodded at Jeff and closed my notebook, letting him know I had what I needed. He shifted back in his chair and placed a hand gently on her forearm. You're doing okay, Eva, he said, somewhere between a question and an observation. I fiddled with my papers, fitting them into my backpack, avoiding standing up just yet. I wanted to give Eva something, some closure, some peace, and thanks for her having given me her story. I wanted to absolve her, to say I forgive you. But all I could manage was, you're not alone. You're not the only one this has happened to. But that wasn't the truth, or at least not all of it, because in the end there were a million reasons why it hadn't happened to me. What mattered was that it had happened to her, and she was still alone.
Okay, thank you, panelists. We have about 10 minutes, I guess, for questions and comments. Yes.
I have a comment for the first talk, although I'm left almost speechless from the second one. It was so powerful and beautiful. I was thinking about when you were distinguishing the case from the other 4 examples, and it struck me that the experimental drugs cases and the physician-assisted suicide cases also have the protection of the public and the third party very heavily embedded in them. So the experimental drugs, it's not merely protecting the dying person from a dangerous drug, but there are really serious problems with allowing people access to experimental drugs that will destroy the whole system we've set up to regulate drugs. And if you can get them without being in a trial, you'll never be in a trial, and it will never succeed. So that's a really powerful public interest argument in a way that in Carhart you just don't have. And in the physician-assisted suicide, I think, to me, those cases at the base are just sort of a horror with the idea of physicians being involved in providing death. No matter how moving the cases are, this sort of abstract theory that a doctor is a healer, and even, you know, the medical profession feels pretty strongly in that regard too. And so that's not protecting just the incompetent patients, but it's really how our society views healers. And I think your analysis of Carhart, I mean, it's just wonderful, and it's just such a horrifying case. You know, I think you did a really nice job.
Thanks a lot. I appreciate the comments, and I think you're absolutely right about the experimental drugs also having that protecting the public, protecting third parties element. It's funny, it's not as apparent in some of the recent court cases like Abigail Alliance. The courts seem to really emphasize this is protecting the patients, but certainly a lot of scholarship talks about how, well, we do this because it's the only way to protect clinical trials and to get these things tested. So definitely in the broader analysis, it's really about third party protection, that the only way we get new drugs tested is by restraining who gets access to them. And so that, I think, is a very good point. And I actually have to talk about that a little more in the paper, that third-party strand is there with experimental drugs as well. As for the physician-assisted suicide and this horror with physicians being involved in death, and it's interesting because that strand of reasoning the court uses in Carhart too. So the court in Carhart actually gives 3 reasons for the ban. One is this woman protective reasoning. One is actually, they say, the ethics of the physician, that physicians are supposed to be about protecting life, and physicians should not be involved in a death that looks a lot like infanticide. And they say that this intact DNA looks more like infanticide, and it will therefore coarsen physicians and coarsen society as a whole. And so the third strand of reasoning, in addition to woman protective, the way we view physicians and physician ethics is the state's interest in protecting life. And so the court also says that when it looks more like infanticide, it implicates the state's interest in protecting life. So I'm sort of wary of that. Well, we should ban this because physicians shouldn't be involved in death in this way, because that's what abortion is, right? I mean, that's what physicians are doing. They are killing the fetus. The other sort of disturbing thing about what Carhart does is in the life strand of reasoning that this protects life. This is sort of the first time where women are said, you have to sacrifice your health for the sake of the fetus, or for the state's interest in protecting the fetus. So it does also use a third-party rationale. This is the state protecting third parties, that is the fetuses. And so it's really an implicit move to treat fetuses as persons, to say that, as the court does, this is like the compulsory vaccination cases or the regulation of controlled substances cases. This is for protecting the state's interest in the fetus. And so it's an implicit way of bringing the fetus, treating the fetus as a person, and saying, like in compulsory vaccination, where we might have to take some health risks with vaccination to protect the public at large, women have to take health risks to protect the state's interest in how the fetus is killed. The other interesting thing to note about the physician ethics and sort of the role of physicians here is the court, that same idea, physicians, it's unethical for physicians to be engaged in killing in this way. What the physicians who are providers of second trimester abortion, and one of the physicians in particular who's at UCSF and who testified in the Ninth Circuit case, emphasized that this ban, for her, she felt was contrary to her ethical duty as a physician, because she can't consent her patients in the way she normally would. She said this makes her feel like, I have to say, I'm going to have to now perform the procedure in a way that's less safe for you, so I don't have to go to prison. So the risks are to you, the benefits are to me. And that is not how we normally have our physicians do informed consent. It's here are the risks to you, here are the benefits to you, right? And then you decide what you want. So at least some physicians feel that this law now puts them in an ethical bind and is contrary to their medical ethics. And certainly ACOG, which are the American College of Obstetrics and Gynecologists, said that this is medically necessary. We need to have physicians be able to do this.
Svante?
Thank you both for wonderful presentations. I actually had a question about the sentiment of regret, which I think in some ways ties both of your talks together. And it's very interesting to me that the law, Michelle, in your paper, it actually clearly produces regret by enacting the kind of policies that Maya is talking about in her paper. So I'm just interested in how the law talks about regret. I mean, is regret something that's defined? Is it a legal category, or is there a reliance on some kind of common sense notion of the sentiment that sort of animates and drives some of these legal debates?
So actually, I'm glad you asked it, because I think it goes to the issue of informed consent. So it was the question that I was going to ask Maya. And so if I don't answer your part of the question, then you should come back and drill me. But I was thinking about informed consent and the extent to which physicians have always separated physical from mental health. And so the regret question never surfaces. And if we were to actually fix and take seriously informed consent, we would surface questions about the emotional response of regret. And so, for example, with prenatal testing we were talking about just before the symposium started, we might want to say, okay, here is what we think you might experience as a parent of a child with a disability, and here are some parents who are parenting and some children with disabilities, and you'll want to know these things so that you won't somewhere down the road regret having terminated your pregnancy as a result of just, say, a bad alpha-fetal protein or even a bad amnio, so you knew that it was going to be a child with a disability. And instead, what we talk about outside of the context of HIV, where we originally were going to talk just about, here's the risk of having a blood draw and a Band-Aid, is we started to talk about, here are some of the socioeconomic consequences and some of the mental health consequences of getting tested and testing positive for a disease for which there's no cure. One would think that the answer to Carhart's concern and to a host of these concerns would be a much more robust body of disclosure. So you'd say, some women may regret this, the data is pretty shaky, but here are the sorts of regrets you might have down the road. Some women might feel great, and here's the statistics on women who feel great after an abortion and whose lives go on to take a certain track. But instead, we've eschewed the mental health consequences because they're so amorphous, right? So we don't touch it as a legal system, even if it's core.
I think that's right on, and it's not to say that no woman ever regrets her abortion. There are some women who regret abortion, as there are some people who regret any medical procedure. The question is, what's our policy response? If some women or men will regret any type of medical procedure, how do we deal with that? Do we then deny the option to everybody? And in general, in the law, we don't. We try to deal with it by giving more and better information, or that's how we should try to deal with it. So I think that at least what's going on here is regret, this supposed fear of regret, it doesn't seem like they're really taking that regret seriously. That's just an excuse to deny a procedure that is disfavored. And I don't want to, when I emphasize the difference between, well, in these other cases it's about physical harm and this is only about psychological harm, I don't want to diminish concern for psychological harm. That's a problem, that we don't take mental health harm seriously enough. We should take it seriously. What's troubling here is that there's no data to support that there is a risk of mental health harm, and then the response is to deny autonomy altogether rather than try to address any serious concerns about fear of regret or psychological harm resulting from the procedure.
Suzanne?
I have a question for Dr. Oberman. I think what your story does so nicely is describe how the system failed Eva, and you do that in a really powerful way. I'm just wondering, how do you use those kind of findings and those stories that you've collected? What are the implications in terms of informing law, informing policies, informing programs?
So that's been my meta struggle all the way through this. I've written, as I said, books and law review articles and chapters in my academic voice preaching policy responses that I think would be preferable to the single punishment of Eva, even though in her case the single punishment actually saved her life. Her conditions of probation gave her a family and a link she was to take care of. I can't remember how many hours, 200 hours of community service, but she ended up doing it much longer, a quadriplegic couple. So she would get there at 6 in the morning, get them washed, dressed, fed breakfast, get them to work, meet them after work, and bring them home. And it saved her life. It was the first functional family she'd been a part of. She felt important and witnessed and loved. I still feel that there's easier public health policies that would fix it, but I also feel like the instinct to blame an individual for societal ills is so powerful that we're not going to prevent it, that the best that could have been done by our current approach is to punish her in the way that she happened to be punished by a tough-on-law judge who somehow saw the light and chose not to send her to either the juvenile home or the women's prison, where either one was an option for her, but instead to save her life. And I decided to tell the story the way that I did, not in a conscious way. It just it came out of me when I realized that it wasn't just about fear, that it was about longing, and that I experienced the longing as well, and that many of us who are conscious as women can understand not just the terror, or maybe can't understand the terror, but can understand the longing for connection. And if I could experience that longing for connection in a life that was so thick with connection, how hungry must she have been for a baby? Of course she couldn't have just been solved by, here's a Title X clinic, go get contraception. Here's an abortion clinic, go terminate your pregnancy. I mean, for her, the baby represented both her salvation and her excommunication. So I think it's the hardest of all cases of maternal filicide to figure out how to intervene because of the myth of the happy family and the private family. But all it would have taken was an adult to be there to say, I'm safe, talk to me, we'll go through some options. And that would have moved her forward. And that was all she wanted, was an adult to help her take responsibility. And I don't know if it comes out of this piece. I don't know how to use this piece. I know that it doesn't seem to come out, at least not to reach an unconvinced audience, out of law review articles, which are never read anyways, or out of books, which are read a little bit more, but by the smallest of audiences. So I really, I wish I could figure out the answer of, the meta answer, like, where does this thing go? But my goal was to explain it in a way that seemed true to me, and my voice in my academic work tells only a partial truth.
I'm not a lawyer, but I want to kind of follow up on Suzanne's question, because as somebody who's a sociologist and a public health researcher and interested in using that work to influence law and policy, one thing I was thinking about your talk, Maya, was, there's all this evidence, public health evidence and medical research that shows that this is a safe, a form of abortion and so forth, and yet it doesn't really get considered by the judges. And where does research kind of fit? Not only just in that particular case, but sort of in the law and in the way that judges make their decision. And then, just in terms of your presentation as well, kind of thinking about this work that you've done. Not so much in terms of influencing law, but to me, the thing I was sitting there thinking, there's a few times when you said women who kill their babies, and I was wondering, should we really be saying, at least for Eva in that situation, is it really the women who have killed their babies, or is it this bigger system of that's let her down, that that you're talking about all the different places to lay blame, should we really be talking about it as women who kill their babies?
Yeah, one of the striking things about the case, and there was a lot of writing about this, sort of how much deference should the court give to the legislative fact-finding here, which was contrary to all the medical data. But what's striking is how the court ignores the data out there. And more than ignores it, it expresses that it doesn't care about the data. We don't really care that we have no reliable data to support this claim. We have our own sense of how women do feel, or really how women should feel. And even the medical data was completely clear that this procedure is medically necessary for some women. Six federal courts, 3 trial courts, 3 federal appeals courts, very carefully canvassed extensive evidence. And they all concluded that the so-called evidence on the other side, that this was not medically necessary, was not credible. It was testimony by doctors who were not abortion providers and had never provided second trimester abortions. And it was basically political testimony. And it's striking how much it does not matter at the end of the day to the court. Maybe you could say the same thing about medical marijuana, right? That there is plenty of medical data that for some patients, marijuana is medically necessary. Federal law actually says, even though it's not true, according to current evidence, that there's no medically beneficial use to marijuana, and that's why it's a Schedule I drug. But in the marijuana cases, the court doesn't, the justices don't say, yeah, we're just going to defer to legislative fact-finding there. They sort of just say, well, at the end of the day, we're going to allow the federal government to ban marijuana, at least that's the lower court case. Supreme Court hasn't addressed the sort of substantive due process right to access medical marijuana. But lower court cases say, well, this is to protect those people who'd abuse recreational drugs. We recognize even that some patients might be harmed, but there's nothing we can do about that here, is what they say. So it seems like the courts are free, the law is free to ignore medical data in several cases.
So the problem with being a public health law person is that the law part of us is really set up to find individuals to blame or individuals to be harmed incidentally while we're aiming at some greater good. And I feel like in this particular area, women's reproductive health, I feel a sense of real abortion fatigue. I'm so tired of the pro-life, pro-choice debate. I very consciously use the word baby to refer to Eva's fetus. I feel like everybody, regardless of what side they're on this stupid debate, and it's not stupid, but I'm so sick of it, needs to really get down to brass tacks and recognize the sorts of things that go on in a woman's life, a girl's life, when she's carrying a baby, that a baby represents for her the future. It's a future that she, at some level, wants, and that women don't cavalierly choose to terminate a pregnancy because they want to fit into a bikini, and that to fixate on the easy case or the hard cases or the bizarre cases rather than on the relatively commonplace cases is to do not just a great disservice to women, but an equally profound disservice to fetuses. Right, and so in a way, this work, as perverse as it's been for me, focusing on mothers who kill their children, has been the lens into what I view as what should be the broader debate, the one that you're suggesting, which is how we receive children, whether they're children like Eva, who are being bounced around from house to house looking for connection, or whether they're children like the one that she carried, that she wanted but couldn't possibly have under the policies we have. So there was blood on everyone's hand in that case, and I feel like it's blood that's there in the abortion cases, top to bottom. And perhaps that's going to be the way that we move as a society beyond the impasse that we're at. Perhaps we're not destined to move there, and it'll run us right into problems about money, but then at least we can be honest about abortion being a money problem, not a morality problem.
Okay, one more question.
I have a question for Michelle about, it seems pretty evident that you're pretty sure that the system has failed Eva and many other women in her situation. And I wonder if you have any insight on what a system that wouldn't fail these women, that actually would be helpful to these women to look like. Obviously, casting blame on the woman who is pregnant is not productive. So how can we shift this?
So up until now, my work has been mostly numerator without denominator. And the interesting work to be done would be work on women who are near misses or not even near misses, right? So, what's the resiliency factor in women who are at risk and yet choose wisely either to terminate, to surrender for adoption, or to carry their babies to term safely. I can tell you from my empirical work that when I've presented it, so my empirical work, all numerator, I end up collecting stories from the audience and from the newspapers and from wherever about the near misses. And generally speaking, the common denominator there is that there was one adult who intervened. That all it takes is somebody announcing themselves as safe, somebody witnessing you. So it's a pastor who calls up and says, hey, are you doing okay? It's the neighbor who knocks on the door and says, I don't want to step out of bounds here, but it seems like you're pregnant. Can I help? right? In these cases, you've got a family system that is in denial and not functional, but it's a school teacher who announces herself as safe, or a friend who's just a step more mature, who says, I heard something about a safe haven law. I'm not a believer in safe haven laws. They wouldn't have helped somebody like Eva. But if her friend had heard of it, if her friend's father had heard of it, if her teacher, right? So in a way, I think that the public health policy solution coming out of this comes from recognizing that we owe one another duties, and from being able to take the risk that the stepmother, the biological father, the mom, the stepdad, nobody was willing to take, even though they knew she was pregnant. Just getting involved, just a little bit, would solve it.
Okay, thank you very much to the audience, and especially thank you to our panelists.
I have so many notes here. I'm really interested in what you're writing. Thanks. I had a sabbatical.